Good morning, 8th grade. It is time for social studies story time. Everyone's favorite time of the day. So we're continuing on with chapter 8 today and reading 8.2, the lower federal courts. So if you remember from yesterday, we started on the court system and did a little bit about how our court system is set up, and specifically looked at jurisdiction, so which courts hear what kind of cases. So we're going to be continuing on today, hopefully looking at those notes and how my daughter did her notes helped you out a little bit with a reminder of how to do those, so that you're doing some really good notes to help you out. Remember, you do get points for completing your notes this week. And then you can, of course, use them on your Galileo test at the end of the week, which I have not posted yet for you to be able to take because I didn't want people to feel rushed to get through the chapter pages. So it will be up there. Don't worry. I know it's not on there yet, but I just didn't want people to feel overwhelmed and rushed that it was there when you check into Galileo for something else during the week. So today we're going to do section 2, the lower federal courts. And the main idea of this section is that Congress has created a system of lower courts for the federal judicial system. Each court has a specific role to play in the judicial branch. So that's what we're going to be looking at overall. I will be showing you pictures from the book because although you have access to them either in the PDF or in the packet that you picked up, it's all black and white, and sometimes it's helpful to see these charts and things in color. So, why it matters. The importance of the lower federal courts. The lower federal courts may not get the attention that the Supreme Court does, but are equally as important. In any one year, for example, the lower federal courts handle about 99% of the federal cases. From bankruptcy to taxes, from kidnapping to terrorism, the lower federal courts have literally heard it all. Their importance is told by more than numbers alone. In the absence of a Supreme Court ruling to the contrary, the lower federal courts determine what the law is. Their rulings set precedents to which other courts refer. Also, over the years, the lower courts, especially the district courts, have been the scene of some dramatic and historic cases, including the treason trials of former Vice President Aaron Burr, 1807, and the communist spy trials of Julius and Ethel Rosenberg, 1951. These and many other moments of courtroom drama, as well as the countless more routine cases, help illustrate the role of the lower courts in our federal judicial system. So, here is a chart on this page that has the federal courts caseload from 2006. So, like, when you guys were born. Yeah, remember our book is a little bit old, but it does give us a general idea. And I'm going to show it to you in just a moment because in color I think it makes more sense. But you'll see that the district courts heard 328,401 cases. The Federal Courts of Appeals, 66,618, and the Supreme Court, 8,521, which has a note by it that says, filed during the 2005 term. So they were filed during 2005, and then they were heard during 2006. So here is that chart. There we go. You can see it there. You do not need that in your notes, but it's important to understand why these are important, because remember in the last section of the chapter we talked about that the Supreme Court only hears a very small percentage of the cases that are brought to it, and so they are looking at ones that critically address the Constitution for the most part. And so they're looking for those really important cases. And then these other ones, it's not that they don't get heard, but a lot of times they will be passed on to those lower courts because they can hear those as well and make decisions, but they are not necessarily affecting the rule of the land or asking constitutional questions as much as these cases. Holy cow, I'm getting a bunch of remind messages right now. Wow. That's good, though. It means people are asking questions, right? Or maybe my kids have a Zoom call. I don't know. We'll find out later, I guess. All right. So, moving on. It's our first blue. Make sure you put it blue in your notes, or that you just started over at the margin, right? Because we're taking good notes. It's good skills that you're going to need in high school and beyond. So I know that it's not your favorite thing to do, but it's very helpful. That's why we make you do it. In my class, in math, in science, you do a lot of notes. This is why, because it's a life skill. You're going to need it. When I go to meetings, I still have to take notes. Still a skill I am using outside of being in school. In my professional life as your teacher, I still need to do that. So that's why we're hard on you about those. Take your notes. All right, federal district courts. As discussed in section 1, the federal court system consists of 3 basic tiers. The district courts occupy the lowest tier. As the trial courts of the federal system, with original jurisdiction for most federal cases, district courts are the workhorses of the federal court system, handling over 300,000 cases a year, as was shown in that graphic we were just looking at. There are 94 federal court districts. Each judicial district has at least 2 judges, though some districts have many more. The U.S. Judicial District for Southern New York, which includes New York City, is the most active federal court district in the country. To handle its large caseload, it has 44 judges, the most of any federal district. So they're going to have more judges because they are a much more populated area. So they're going to have to hear more cases, handle a higher caseload, and that's why they need more judges working in that capacity. Okay, so now we're on subsection up here in red. The jurisdiction of district courts. What sorts of cases are tried before federal courts? The Constitution explicitly assigns some types of cases to the federal courts, such as those involving residents of different states or the United States and a foreign government. In addition, Congress has classified a number of offenses as violation of federal law. Civil offenses include violations of civil rights statutes and employment laws. Criminal offenses range from the destruction of aircraft to making false statements in a legal proceeding to murder. All told, district courts handle about 215,000 civil cases and 70,000 criminal cases each year. In serious criminal cases, district courts convene panels of citizens known as grand juries to hear evidence of a possible crime and to recommend whether the evidence is sufficient to file criminal charges. Grand juries consist of 16 to 23 people. Grand juries are not used in civil cases. Bankruptcy cases fall under federal jurisdiction as well. Bankruptcy is a legal process by which persons who cannot pay money they owe others can receive court protection and assistance in settling their financial problems. Each district court includes a separate bankruptcy court with its own judges and procedures that handles only bankruptcy cases. The bankruptcy court for the Southern District of New York has 11 bankruptcy judges. So again, a larger number than other places would have, simply because they're going to have a higher caseload with a larger population. So that is the end of this subsection, and it's hard to see in your black and white copy, but there are a couple of our vocab words in there. Remember, you don't need to put those in your notes today if you do the Quizlet. So send me evidence that you've done the Quizlet, a screenshot, a picture that you take of your screen, something that you can show me that you're doing the Quizlet, because that way it's much more fun. And you don't have to write down the 20-something words that are in this chapter. There's a lot of vocab. So, much better way for you to remember it that way. So, here I'll show you the map there, because now you can see it in color. Feel free to pause. There's a button for that. Yay, YouTube. And then you can look at the details there. It shows you what the circuit court numbers are and where their jurisdictions are. So, also not on the test. Don't worry about it. But even if it were, it's open notes and open book this week. So, trying to help you guys out. Okay, next subsection is on court officials. Judges are the primary official in any court. The judge's main job is to preside over trials. He or she makes sure trials follow proper legal procedures to ensure fair outcomes. The judge also instructs juries about the matters of law they are to decide. In some cases, the participants in a trial may agree not to have a jury. In such cases, the judge decides the case. As you read in Section 1, district court judges are nominated by the President and must be approved by the Senate. As Article 3, judges, they have no set term and can serve until they die or retire. Bankruptcy judges, however, are named by the courts of appeals for their circuit in which the district court is located. As Article 1 judges, bankruptcy judges serve 14-year terms. And if you remember from Section 1, it's 14 years because that is longer than any one president would be in office. And so that ensures that they are not going to have that influence from the political system as much. Okay? All right, moving on. District courts also have officials who are known as magistrate judges. These officials are responsible for overseeing some of the early hearings of a criminal trial when routine matters are carried out. They may also hear misdemeanor minor criminal cases punishable by 1 year or less in prison time, and certain civil cases. Magistrate judges are appointed by the district court judges to terms of 8 years. Each district court has a clerk of the court. This person performs such non-judicial jobs as maintaining court records, handling money received in fines and fees, and overseeing the jury recruitment process. So if you remember from when we talked about rights and responsibilities, serving on a jury is one of the things that we discussed during that portion of our book, which is quite a while ago actually, but that's what this falls under. Okay, and then we have our next subsection, other courtroom officials. Each judicial district has a number of other officials who are not employees of the court, but who are vital to its operations. The most prominent of these is the U.S. Attorney. Each judicial district has one U.S. Attorney. The U.S. Attorney's job is to represent the United States government in federal court. When a person is charged with a federal crime, for example, the U.S. Attorney or an assistant acts as prosecutor. That is, he or she tries to win a guilty verdict. If the United States is involved in a civil suit, U.S. Attorneys represent the government. U.S. Attorneys oversee an office with numerous assistant U.S. Attorneys and other staff. For the Southern District of New York, for example, there are more than 220 assistant U.S. Attorneys. U.S. Attorneys and their assistants are employees of the U.S. Department of Justice, making them part of the executive branch. U.S. Attorneys are appointed by the President, subject to Senate approval, and serve a 4-year term, though a president has the power to replace them before their terms end. In criminal cases, the federal courts provide lawyers to defendants who cannot afford to hire one. Such lawyers are known as public defenders. Public defenders are appointed by the panel of the judges who make up the Court of Appeals. Each judicial district is also home to an office of the United States Marshal's Service. Among other duties, U.S. Marshals provide security and police protection at federal courthouses. Marshals also transport prisoners, help track down and arrest people accused of crimes, and provide protection to witnesses in federal cases. The head of each U.S. Marshal's office is appointed to a 4-year term by the President, with the advice and consent of the Senate. These appointees are employees of the Department of Justice. So you'll notice as we're going through all of these different people who serve in these capacities, a lot of them are chosen by the President, but you'll notice that they keep being approved by the Senate, and that's part of our checks and balances system. So we have the executive branch is nominating, choosing those people, but then they have to also be confirmed by the legislative branch, and then they're serving in the judicial branch. So it's how all three of those are influencing each other, right? All right, now we're on to our next section within this chapter, right? The Federal Courts of Appeals. The middle tier of the federal court system is made up of the Courts of Appeals. Today there are 13 of these courts. 12 are scattered among the 12 regional circuits into which the country is divided. Washington, D.C. is both a judicial district and a circuit. In other words, it has a district court and a court of appeals. One court of appeals, the Court of Appeals for the Federal Circuit, has nationwide jurisdiction to hear certain types of cases. Okay, now we're in the subsection below that, the red here. Purpose of the Courts of Appeals. The Courts of Appeals are, as their name suggests, appellate courts. They hear cases on appeal from the district courts within their circuit. They also hear appeals from various administrative agencies of the federal government. For example, people dissatisfied by a ruling by the Social Security Administration about retirement benefits may appeal to a court of appeals. Each year, the Court of Appeals hear about 65,000 cases. The vast majority, about 3 or 4, are criminal and civil based. Oh, so 3 of 4. So 3/4, 75%. In criminal cases, the appeal will be filed by a defendant who was found guilty. The federal government cannot appeal a verdict of not guilty. In civil cases, either side can appeal. Regardless of who files the appeal, few appeals are successful. In 2006, for example, fewer than 4% of filed cases were successfully appealed. Appeals court procedure. A person who files an appeal, the appellant, usually has to show that the original ruling was based on a legal mistake. In almost all cases, the Court of Appeals will overturn a case only if the original court or agency followed an improper procedure. Courts of Appeals do not retry cases. They do not permit new evidence to be introduced or hear testimony from witnesses. Instead, they rely on factual record as established by the trial court. Only in rare instances will appeals courts rule that the original court or agency misconstrued or drew a wrong conclusion from the evidence. Most appeals are heard by a randomly chosen panel of 3 circuit judges. Usually, the panel reviews the trial court record and reads written arguments or briefs from both sides of the case. In some cases, the court may listen to oral arguments from each side as well. When that happens, the government's side of the case is presented by the U.S. attorney who originally tried the case. So, now there's another caseload chart that I'm going to hold up for you here so that you can pause and take a look at it as needed. Again, this information, good to look at, important for you to understand and see the caseload, and it shows how it breaks down. Here, I'll show you again. It breaks down the number of cases that are overturned and then the total number of appeals cases. So that's going to be hard for you to see on your black and white copy, but to give you an idea of what a small percentage that really is. All right. After the ruling. The ruling of a court of appeals is usually the final word on a particular case. In some cases, though, the court might send the case back to the district court for additional hearings. If the panel finds in favor of a criminal defendant, the prosecutor may decide to retry the case, though that is rare. The case may, on occasion, get further review from a larger panel of judges. This type of review is called an en banc review. Sorry, it's not English. I don't speak that language. And it often involves all the judges of a specific court of appeals. In a small number of cases, the ruling of the Court of Appeals may undergo review by the U.S. Supreme Court. You will read more about this process in Section 3. So, tomorrow, that's what we're going to be going over. The Federal Circuit Court. The 1982 Congress created the Court of Appeals for the Federal Circuit. This court has nationwide appellate jurisdiction for cases involving certain areas of law, such as international trade, government contracts, patents, and trademarks. Appeals come to the court from the federal district courts, from government agencies, and from some specialized federal courts that you will read about below. So that's what we're going to continue on and look at right now. So, we're almost done with this chapter, actually, or chapter section. So now we're down here, other federal courts. It's a lot to take in, I know. And it's important that you understand overall how this system works, because it's there to protect you, or someday you might be more involved in this, but the detail stuff isn't stuff that is going to be important to hold on to. You just need to have an idea of how this functions and what the general structure is. So, last section, yay! In addition to the district and circuit courts, Congress has created other Article 3 and Article 1 courts. These courts generally have a very limited jurisdiction to deal only with certain types of cases. U.S. Court of International Trade, so that's the first one. These you definitely need to have in your notes, so make sure you have the red and that you know what each of these is, okay? That's going to be important. This court hears cases involving disputes over the laws and rules governing international trade. For example, an importer who believes he or she has been wrongly denied the right to bring a product into the country may seek relief from this court. Because it is an Article 3 court, its judges nominated by the President and approved by the Senate can serve for life. The cases from this court can be appealed to the Court of Appeals for the Federal Court Circuit. Okay, the U.S. Tax Court. The U.S. Tax Court hears disputes over federal taxes. If a citizen disagrees with a judgment by the Internal Revenue Service, he or she can seek redress in this court. Tax court decisions can be appealed in the Federal Court of Appeals. Okay, our third one is the U.S. Court of Appeals for Veterans Claims. Congress created the Department of Veterans Affairs to administer programs for the men and women who served in the military. Sometimes disputes arise over a veteran's benefits, disability payments, or some other matter. The Court of Appeals for Veterans Claims hears these cases. It is located in Washington, D.C. Okay, our fourth court is the U.S. Court of Federal Claims. In general, a sovereign nation is immune from being sued unless it agrees to be sued. This general principle is known as sovereign immunity. Congress, however, has identified circumstances in which parties can bring complaints against the U.S. government. To hear cases in which money claims are more than $10,000, Congress established the U.S. Court of Federal Claims, located in Washington, D.C., across from the White House. Rulings of this court can be appealed to the Court of Appeals for the Federal Circuit. Then we have 4 more courts. There's a lot. So, next one is the U.S. Court of Appeals for the Armed Forces. Members of the military are subject to the Uniform Code of Military Justice. This code addresses the special and unusual need for order and discipline in the military. In cases of violation of the code, the military holds hearings called court-martials to decide the cases. Congress has created a court to hear appeals from these court-martials. The 5 judges on this court are civilian, not military personnel. They serve 15-year terms. As civilians, they are not subject to the military command structure. Then we have national security courts. Congress has created 2 special courts charged with balancing the demands of the national security with the rights of U.S. citizens. Foreign Intelligence Surveillance Court was established in 1978. Its job is to review and authorize requests by the government to conduct spying operations on American soil if it determines that the target of the investigation is an, quote, agent of a foreign power. The court is made up of 11 district court judges appointed by the Chief Justice of the United States. They serve for 7-year terms. The Alien Terrorist Removal Court, which Congress created in 1996, reviews requests by the U.S. Attorney General to remove from the country an individual suspected of being a terrorist. Judges are appointed to this court by the Chief Justice of the Supreme Court and serve 5-year terms. So, in your notes for the test, don't worry about how long the terms are on all of these. That's going to be a little bit overwhelming, too much information. So I really want you to just focus on that there are these different kinds of courts and then what kind of specific material they handle, because that's more important to understand conceptually than some of those detail things. Okay, we got 2 more and then we are done for today. Military commissions. During combat operations in Afghanistan following the terrorist attacks of September 11, 2001, U.S. military forces captured many individuals whom they classified as enemy combatants. President George W. Bush created a special military commissions to try these individuals. Modeled on U.S. military tribunals set up during World War II to try war criminals from Nazi Germany and Japan, the commissions were outside the normal judicial system. Their legality was challenged in federal court in Hamdan v. Rumsfeld, 2006. The Supreme Court struck down the procedures, method, and powers under which these military commissions operated, forcing Congress and the President to draft new rules. These new rules are themselves being challenged in federal court. Well, they were at time of printing on this, but remember, I believe our print date on this is 2011 or 2012, so maybe if you're interested, that's something you'll want to look up. And our last one is Washington, D.C. and territorial courts. Congress has governing responsibility in Washington, D.C. For Washington, D.C. And the U.S. territories of Guam and the Virgin Islands and Northern Mariana Islands. Accordingly, Congress has authorized the creation of local trial and appellate courts in each of these places to try local cases. These courts are distinct from the Federal District Court and the Federal Court of Appeals in these jurisdictions, which hear federal cases. So, that's it for our reading. It wasn't as long today, thank goodness, because that first section was super duper long, and it looks like, I'm looking forward to tomorrow's. Tomorrow's is going to be a little bit longer than today, but that's all right. So again, you do not have to answer these questions at the end, but I do recommend that you review them because it's going to cover some of the essential topics. All right, that's it for today. I hope you guys have get some good notes done, and then I will, hopefully you'll send them to me. I can grade them, and they will help you out on your test later. Thanks.